has claimed, I have an Article 2 where I have the right to do whatever I want as president. He has said, I have the right to do anything I want to do. I am president of the United States. Do you believe that the president is able to do anything he wants to do?
A Senate hearing turned explosive after Amy Klobuchar confronted a Trump nominee over presidential power and a controversial abortion case involving a 10-year-old rape victim.
Mr. Flowers, in 2020, as Ohio Solicitor General, you filed an amicus brief in a Supreme Court case that asked the court to challenge the administration of the 2020 election in Pennsylvania. The president has now issued an executive order to overhaul our nation's elections and assert federal control over state-run elections. Minnesota and 18 other states sued and won a preliminary injunction. Do you agree with what the judge presiding in that case wrote? He said, or she said, the Constitution does not grant the president any specific powers over elections.
So, Senator, I can't comment on, as a judicial nominee, on any pending litigation. And as you described it, it sounds as though this litigation is pending. So I believe I shouldn't say anything.
Okay. I will note that you did sign this brief, and I'm reminded of one of our colleagues said when we had a nominee in front of us, Caitlin Halligan, where questions were raised of a brief she filed as Solicitor General in New York, and one of our colleagues said, some of our colleagues have argued that we should not consider this aspect of her record because at the time she was working as the Solicitor General of New York, but no one forced her to approve and sign the brief. And I think that we should consider that as we look at your record. Mr. Schwartz, President Trump has claimed, I have an Article 2 where I have the right to do whatever I want as president. He has said, I have the right to do anything I want to do. I am president of the United States. Do you believe that the president is able to do anything he wants to do?
So, Senator, without commenting on those specific words, and I don't know the context for them, we obviously have a constitutional system of checks and balances. The executive branch is obviously very strong in certain areas and has tremendous amounts of power and discretion. And in other areas, the other branches have power and discretion, and there's a balance amongst them. So, Senator, without knowing the context of that, I really couldn't comment further on it.
Okay. Mr. Flowers, as Solicitor General, you defended Ohio's law that banned abortion before most women know they're pregnant at just 6 weeks, which included no exceptions for rape or incest. And as you know, a 10-year-old girl in Ohio got pregnant when she was raped. Following her rape, she couldn't get the care she needed at home. And because she was 3 days past Ohio's 6-week limit, and there was no exception for rape, so she had to travel to Indiana to get access to abortion care. You urged the court to lift a trial judge's preliminary injunction of Ohio's abortion ban, arguing each day the law was enjoined, it inflicted, quote, irreparable harm, end quote, on the state. Do you believe that this girl and other women in the state who were impacted by the law suffered irreparable harm?
Senator, anyone who's raped, and particularly a child, suffers irreparable harm. There's no doubt about that. As Solicitor General, my job was to defend the laws of the state. And if I had a good faith basis for doing so, I would do that. And again, that was true regardless of whether the law had a liberal or conservative valence. I defended them all when we had a valid constitutional basis to do so.
Well, given that you argued the court should uphold Ohio's law a full year after this incident with this 10-year-old Ohio girl who was raped, what would you say to litigants who question that you can be even-handed in applying the law, including to women trying to vindicate their rights?
Senator, it will be my top priority to ensure that litigants, as I said about Chief Judge Sutton, recognize that I'm fairly considering the cases that come before me. In the case to which you're referring, when we argued for irreparable harm, we were relying on a doctrine that says that when a state law is enjoined, that is per se irreparable harm. So all I was doing was advancing settled legal principles as applied to that case.
I think a judge's job is to apply the law to the facts, and I'm just looking at the facts of that case. And I think most people would believe that it was the girl suffering irreparable harm. Mr. Flowers, you've argued that timidly, those are your words, timidly, following the principles of textualism and judicial restraint is, quote, unacceptable for the conservative movement of today, which seeks to reverse not just arrest, our national decline. A movement that wants to kneecap the administrative state will not be satisfied with a court content merely to erect some hurdles. What agencies do you want to kneecap?
Senator, I didn't say that I'd want to kneecap any agencies, and I couldn't express views on policy matters anyway. What I was addressing in that article was particularly the Supreme Court and certain resistance to textualism among some younger attorneys that I was meeting at law schools. I was not saying that those are my personal views.
But is the quote not a movement that wants to kneecap the administrative state? What is the administrative state if it's not agencies of the United States government?
So, Senator, I wasn't describing my views. I was saying that for the people who wish to curtail the administrative powers, they would not be content with a certain approach to textualism. And I was speaking only about the Supreme Court. As a circuit nominee, I'd be bound by precedents of the Supreme Court, and I'd faithfully apply them.
And I just want to note one agency, the FTC, helps enforce our antitrust laws, something I care a lot about, as does the chairman. And it has put millions of dollars back in Americans' pocketbooks. In 2024, the FTC returned $337 million to refunds in consumers. It's just one example. When I hear the words from a nominee that they want to kneecap the administrative state, and that is not to say we don't need reforms and laws passed to make things work better, but to me, that just makes me really concerned of impartiality when it comes to a judge. Thank you.
Thank you. Before I call on Senator Blumenthal.
Senator Amy Klobuchar opened this tense hearing by zeroing in on one of the most controversial questions in American politics today. How much power should a president actually have? Referencing statements from President Trump claiming he had the right to do whatever I want, Klobuchar repeatedly pushed judicial nominee Mr. Flowers to say whether any president is above constitutional limits. While Flowers avoided directly answering, he emphasized that America's system relies on checks and balances between the executive, legislative, and judicial branches. The exchange became increasingly uncomfortable as Klobuchar brought up Flowers' legal record as Ohio Solicitor General. She highlighted his involvement defending Ohio's 6-week abortion ban, a law with no exceptions for rape or incest. That immediately shifted the hearing from constitutional theory into an emotional and deeply personal issue. Klobuchar referenced the now nationally known case of a 10-year-old rape victim who had to leave Ohio to obtain abortion care because she was past the state's legal limit. Flowers attempted to separate his personal beliefs from his role as a lawyer representing the state. He argued that his job was simply to defend laws that had a constitutional basis, regardless of whether they were politically conservative or liberal. But Klobuchar wasn't focused only on legal procedure. She repeatedly brought the conversation back to the real-world consequences of those laws, arguing that the true irreparable harm in the case was suffered by the child involved, not the state government defending the law. The hearing then shifted into another major ideological battle, the role of the federal government itself. Klobuchar challenged past comments linked to Flowers discussing efforts to kneecap the administrative state. That phrase immediately raised concerns about agencies like the FTC and other federal institutions responsible for enforcing consumer protections and regulations. Flowers tried to distance himself from the language, saying he was describing broader legal movements rather than endorsing the idea personally. By the end of the hearing, the central issue became trust. Klobuchar's questions reflected broader fears among critics who worry that some judicial nominees may prioritize ideology over impartiality. Supporters of nominees like Flowers argue that judges must apply the law as written, even when cases involve emotionally difficult circumstances. But opponents argue that legal philosophy cannot be separated from real-life consequences. That tension, between strict legal interpretation and human impact, became the defining clash of this hearing.